everyone that we hope is watching from home. Welcome to Ladies, Lipstick, and Litigation, a video podcast that I have somehow talked Heidi into doing with me. My name is Jeunesse Rutledge, and I work at Reinhart, Van Duren in Milwaukee, Wisconsin. I'm a litigator that focuses on brand protection work, specifically advertising and trademark spend. And Heidi, why don't you introduce yourself?
Hi, everybody. My name is Heidi. I also work with Jeunesse at Reinhart in Milwaukee. I focus on trademarks, copyright, and entertainment law. And essentially, Jeunesse and I nerd out about this stuff all of the time. So we thought we'd invite you to the conversation as well.
Yeah, so we thought we might as well, have you here, and hopefully you learn something and gain something from it. Our first topic today is on shoes that I cannot afford but would love to be able to afford. Specifically Louboutin and Valentino shoes. And one of the major issues in these cases is distinctiveness and what that means in the trademark world as it relates to registration. So Heidi, can you talk a little bit about distinctiveness as it relates to trademarks?
Sure. So distinctiveness is really the core element of what a trademark is. Essentially, a trademark has to tell you where the goods and services come from. We see trademarks all the time, usually words or slogans, but a trademark can really be anything. It can be a color like Tiffany blue or UPS brown, sounds like the roaring lion on the MGM films, or I think I've even seen a couple of registrations for smells, which is kind of weird, but
okay.
The converse is not true. Not everything can be a trademark. In order to be a trademark, whatever it is, whether it's a word, a color, a sound, it has to convey the source of the goods or services.
Man, I think we could both use a little more Tiffany blue in our lives.
Absolutely.
So one of the issues in the Louboutin case specifically is the red sole. They were trying to register the red sole, right?
Right.
Yeah, and I wore red in honor of that in case Louboutin wants to send me some shoes that might match the dress, hint, hint. But the major issue in that was distinctiveness of the red sole. Can you talk a little bit about how this case came about and what happened?
Yeah, so actually Louboutin had been successful at the Trademark Office in getting their mark registered. But in 2011, Yves Saint Laurent came out with this really interesting line of shoes. They were all monochromatic. Some of them were yellow, some were green, and the ones that really were the issue were the ones that were all red. Louboutin said that this infringed on their distinctive red sole trademark, and so they brought the case to district court. The district court said that the red sole was not a trademark and could never be a trademark in the fashion industry. So Louboutin appealed to the appellate court, and actually the appellate court agreed. They looked at how long Louboutin has been selling these shoes, since 1992, so almost 30 years, how much they've spent on advertising, how ubiquitous it is in the fashion industry, and the fact that their competitors, even though they're a little begrudging about it, notice that when you see that red sole, you know it's a Louboutin shoe. So the appellate court agreed that the color red, when it's applied to the sole of a shoe, functions as a source indicator because people look at it and say, I know where that shoe comes from.
I'm going to sidestep the fact that 1992 was almost 30 years ago for a moment. One of the issues in that case, too, was that the sole was a different color than the top of the shoe, right?
Yes. So this case was a win for Louboutin in the fact that they found their trademark was validated, but the appellate court also limited the scope of their trademark rights. They said their trademark right was specifically limited to a red sole that contrasts with the rest of the shoe. Because the Saint Laurent shoes were monochromatic, they were red everywhere, that wasn't necessarily an infringement. So even though it wasn't necessarily an infringement, it validated their trademark, which was still a win for Louboutin and their fabulous shoes.
Yeah, I would love some of those fabulous shoes in my life. Speaking of more fabulous shoes, Valentino is trying to make a similar argument as Louboutin in registering its rock star studs, rather. Have you seen the Valentino shoes with those little pointy studs on them?
Oh, yes, I have. I think I have a couple in a shopping cart.
You know, I do that too, and hope and pray that one day they'll just magically appear at my door. But Valentino is following Louboutin's logic very closely as it relates to the red sole, and saying that their studs have become so distinctive that consumers see that stud and automatically think these are Valentino shoes. They're on very specific designs of shoes, all of which I would like. And so they haven't been successful so far at the USPTO. They had 3 applications rejected for being descriptive rather than distinctive. So they're working on it. They're appealing that case right now, and hopefully, you know, or we'll see what happens with that case. But they used very similar evidence as Louboutin, gave advertising spend, over 200 pages of evidence showing the length of the use of these studs, consumer impressions, etc., that are all important for distinctiveness.
Interesting. And that actually brings up a really good point. You mentioned that they received a rejection because they were descriptive. The Trademark Office finds that things can be descriptive and they're not immediately a trademark, but they can build up distinctiveness or become indicators of source and brand over time. So exactly as you mentioned, they'll look to things like advertising spend, recognition among consumers, and things like that. So it's kind of cool that things can become trademarks over time.
Mm-hmm. Yeah, well, I would love a couple pairs of all the trademarks that we've talked about today. And hopefully one day we'll get there. So thank you all for listening. We hope that you learned something on distinctiveness as it relates specifically to shoes that we cannot afford currently, and trademarks and fashion distinctiveness. Tune in next time. We're going to be talking about a little chew toy that gave Louis Vuitton quite the headache. And we'll move on after that. Hopefully we'll talk about diamonds. We'll talk about athletes. We'll talk about tattoos and all the fun stuff. But if you have any suggestions or things that you'd like to hear us talk about, please feel free to let us know, and we will nerd out about pretty much anything.
Absolutely.
Well, we hope to see you next time on Ladies Lipstick in Litigation. And until then, be fabulous.